Hello, everyone. Today's case is Learning Resources Incorporated versus Trump. This is the tariffs case that's very important in the media right now. So, the question presented is whether the International Emergency Economics Power Act, IEEPA, authorizes the president to impose tariffs. Shortly after taking office, President Trump sought to address two foreign threats: the influx of illegal drugs from Canada, Mexico, and China, and large and persistent trade deficits. The president determined that the drug influx had created a public health crisis and that the trade deficits had led to the hollowing out of the American manufacturing base and undermined critical supply chains. The president declared a national emergency as to both threats, deeming them unusual and extraordinary, and invoking his authority under the IEEPA to respond. He imposed tariffs to deal with each threat. As to the drug trafficking tariffs, the president imposed a 25% duty on most Canadian and Mexican imports and a 10% duty on most Chinese imports. As to the trade deficit reciprocal tariffs, the president imposed a duty on all imports from all trading partners of at least 10%, with dozens of nations facing higher rates. Since imposing each set of tariffs, the president has issued several increases, reductions, and other modifications. Petitioners in Learning Resources and respondents in VOS Selections filed suit alleging the IEEPA does not authorize the reciprocal or drug trafficking tariffs. The Learning Resources plaintiffs, two small businesses, sued in the United States District Court for the District of Columbia. That court denied the government's motion to transfer the case to the United States Court of International Trade, CIT, and granted the plaintiff's motion for a preliminary injunction, concluding that the IEEPA did not grant the president the power to impose tariffs. The VOS Selections plaintiffs, 5 small businesses and 12 states, sued in the CIT. The court granted summary judgment for the plaintiffs, and the Federal Circuit, sitting en banc, affirmed in relevant part, concluding the IEEPA grant of authority to regulate importation did not authorize the challenged tariffs, which are unbounded in scope, amount, and duration. The government filed a petition for certiorari in VOS Selections, and Learning Resources plaintiffs filed a petition for certiorari before judgment. The court granted the petitions and consolidated the cases. Held. IEEPA does not authorize the president to impose tariffs. The judgment in number 24-1287 is vacated and the case is remanded with instructions to dismiss for lack of jurisdiction. The judgment in number 25-250 is affirmed. Number 24-1287, 784, Federal Supplement 3D 209, vacated and remanded. And then number 25-250, 149F, 4th, 1312, affirmed. Okay. The Chief Justice delivered the opinion of the court with respect to Parts 1 and 2A1. Article 1, Section 8 of the Constitution specifies that the Congress shall have the power to lay and collect taxes, duties, imposts, and excises. The framers recognized the unique importance of this taxing power, a power which very clearly included the power to impose tariffs, and they gave Congress alone access to the pockets of the people. The framers did not vest any part of the taxing power in the executive branch. The government thus concedes that the president enjoys no inherent authority to impose tariffs during peacetime. It instead relies exclusively on IEEPA to defend the challenged tariffs. It reads the words regulate and importation to effect a sweeping delegation of Congress's powers to set tariff policy, authorizing the president to impose tariffs of unlimited amount and duration on any product from any country. The Chief Justice, joined by Justice Gorsuch and Justice Barrett, concluded in Part 2A2. The court has long expressed reluctance to read into ambiguous statutory text extraordinary delegations of Congress's powers. In several cases described as involving major questions, the court has reasoned that both separation of powers principles and a practical understanding of legislative intent suggests Congress would not have delegated highly consequential power through ambiguous language. These considerations apply with particular force where, as here, the purported delegation involves the core congressional power of the purse. Congressional practice confirms as much. When Congress has delegated its tariffs powers, it has done so in explicit terms and subject to strict limits. Against that backdrop of clear and limited delegations, the government reads IEEPA as to give the president power to unilaterally impose unbounded tariffs and change them at will. That view would represent a transformative expansion of the president's authority over tariff policy. It is also telling that in IEEPA's half-century of existence, no president has invoked the statute to impose any tariffs, let alone tariffs of this magnitude and scope. That lack of historical precedent, coupled with the breadth of authority that the president now claims, suggests that the tariffs extend beyond the president's legitimate reach. The economic and political significance of the authority the president has asserted, likewise, provides a reason to hesitate before concluding that Congress meant to confer such authority. The stakes here dwarf those of other major questions cases. And as in those cases, a reasonable interpreter would not expect Congress to pawn such a big-time policy call off on another branch. There is no exception to the major questions doctrine for emergency statutes, nor does the fact that tariffs implicate foreign affairs render the doctrine inapplicable. The framers gave Congress alone the power to impose tariffs during peacetime, and the foreign affairs implications of tariffs do not make it any more likely that Congress would relinquish its tariff power through vague language or without careful limits. Accordingly, the president must point to clear congressional authorization to justify his extraordinary assertion of that power. He cannot. The Chief Justice delivered the opinion of the court with respect to Part 2B, concluding, A, the IEEPA authorizes the President to investigate, block during the pendency of an investigation, regulate, direct, and compel, nullify, void, prevent, or prohibit importation or exportation. Absent from this lengthy list of specific powers is any mention of tariffs or duties. Had Congress intended to convey the distinct and extraordinary power to impose tariffs, it would have done so expressly, as it consistently has in other tariff statutes. The power to regulate importation does not fill that void. The term regulate, as ordinarily used, means to fix, establish, or control, to adjust by rule, method, or established mode, to direct by rule or restriction, to subject to governing principles or laws. The facial breadth of this definition places in stark relief what regulate is not usually thought to include: taxation. Many statutes grant the executive the power to regulate, yet the government cannot identify any statute in which the power to regulate includes the power to tax. The court is therefore skeptical that in IEEPA and IEEPA alone, Congress hid a delegation of its birthright power to tax within the quotidian power to regulate. While taxes may accomplish regulatory ends, it does not follow that the power to regulate includes the power to tax as a means of regulation. Indeed, when Congress addresses both the power to regulate and the power to tax, it does so separately and expressly. That it did not do so here is strong evidence that regulate in IEEPA does not include taxation. A contrary reading would render IEEPA partly unconstitutional. IEEPA authorizes the president to regulate importation or exportation, but taxing exports is expressly forbidden by the Constitution. The neighboring words in which regulate is associated also suggest that Congress did not intend for regulate to include the revenue-raising power. Each of the 9 verbs in subsection 1702A1B authorizes a distinct action a president might take in sanctioning foreign actors or controlling domestic actors engaged in foreign commerce, as presidential practice confirms, and none of the listed authorities include the distinct and extraordinary power to raise revenue, a power which no president has ever found in IEEPA. B. Several arguments marshaled in response are unpersuasive. First, the contention that IEEPA confers the power to impose tariffs because early commentators and the court's cases discuss tariffs in the context of the Commerce Clause answers the wrong question. The question is not whether tariffs can ever be a means of regulating commerce. It is instead whether Congress, when conferring the power to regulate importation, gave the president the power to impose tariffs at his sole discretion. And Congress's pattern of usage is plain. When Congress grants the power to impose tariffs, it does so clearly and with careful constraints. It did neither in IEEPA. Second, the argument that regulate naturally includes tariffs because the term lies between two poles in IEEPA: compel on the affirmative end and prohibit on the negative end is unavailing. Although tariffs may be less extreme than an outright compulsion or prohibition, it does not follow that tariffs lie on the spectrum between those poles. They are different in kind, not degree, from the other authorities in IEPA. Tariffs operate directly on domestic importers to raise revenue for the Treasury and are very clearly a branch of the taxing power. Thus, they fall outside the spectrum entirely. Third, the argument based on IEPA's predecessor, the Trading with the Enemies Act, and the Court of Customs and Patent Appeals decision in United States v. Yoshida International Incorporated, cannot bear the weight placed on it. A single expressly limited opinion from a specialized intermediate appellate court does not establish a well-settled meaning that the court can assume Congress incorporated into IEPA. Fourth, the historical argument based on the court's wartime precedents fails. Those precedents are facially inopposite, as all agree the president lacks inherent peacetime authority to impose tariffs, and the attenuation chain of inferences from wartime precedents through multiple iterations of TWEA to IEPA cannot support, much less clearly support, a reading of IEPA that includes the distinct power to impose tariffs. Finally, arguments relying on this court's precedents lack merit. Federal Energy Administration v. Algonquin Incorporated bears little on the meaning of IEPA. Section 232B of the Trade Expansion Act of 1962 contains sweeping, discretion-conferring language that IEPA does not contain, and the explicit reference to duties in Section 232A renders it natural for Section 232B itself to authorize duties. Nor does Dames and Moore v. Reagan offer support because that case was exceedingly narrow, did not address the president's power to regulate, and did not involve tariffs at all. Justice Kagan, joined by Justice Sotomayor and Justice Jackson, agreed that EPA does not authorize the president to impose tariffs, but concluded that the court need not invoke the major questions doctrine because the ordinary tools of statutory interpretation amply support that result. Justice Jackson would also consult legislative history, in particular the House and Senate reports that accompanied IEPA and its predecessor statute, TWEA, to determine that Congress did not intend for IEPA to authorize the executive to impose tariffs. Chief Justice Roberts announced the judgment of the court and delivered the opinion of the court with respect to Parts 1, 2A1, and 2B, in which Sotomayor, Kagan, Gorsuch, Barrett, and Jackson joined, and an opinion with respect to Part 2A2 and 3, in which Gorsuch and Barrett joined. Gorsuch and Barrett filed concurring opinions. Kagan filed an opinion concurring in part and concurring in the judgment, in which Sotomayor and Jackson joined. Jackson filed an opinion concurring in judgment and concurring in judgment. Thomas filed a dissenting opinion. Kavanaugh filed a dissenting opinion, in which Thomas and Alito joined. Chief Justice Roberts announced the judgment of the court and delivered the opinion of the court except as to Parts 2A2 and 3. We decide whether the International Emergency Economic Powers Act, IEPA, authorizes the president to impose tariffs. Shortly after taking office, President Trump sought to address two foreign threats. The first was the influx of illegal drugs from Canada, Mexico, and China, a presidential proclamation number 10886. Okay, so lots of executive orders. The second was large and persistent trade deficits. The president determined that the first threat had created a public health crisis and that the second had led to the hollowing out of the American manufacturing base and undermined critical supply chains. He invoked his authority under IEPA to respond. Enacted in 1977, IEPA gives the president economic tools to address significant foreign threats. When acting under IEPA, the president must identify an unusual and extraordinary threat to American national security, foreign policy, or the economy originating primarily outside the United States, and he must declare a national emergency under the National Emergencies Act. He may then, by means of instructions, licenses, or otherwise, take the following actions to deal with the threat: investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of, or dealing with, or exercising any right, power, or privilege with respect to, or transactions involving any property in which any foreign country or national thereof has any interest. President Trump declared a national emergency as to both the drug trafficking and the trade deficits, which he deemed unusual and extraordinary threats. He then imposed tariffs to deal with each threat. As to the drug trafficking tariffs, the president imposed a 25% duty on most Canadian and Mexican imports and a 10% duty on most Chinese imports. As to the trade deficit, or reciprocal tariffs, the president imposed a duty on all imports from all trading partners of at least 10%. Dozens of nations faced higher rates, and these tariffs applied notwithstanding any extant trade agreements. Since imposing each set of tariffs, the president has issued several increases, reductions, and other modifications. 1 month after imposing the 10% drug trafficking tariffs on Chinese goods, he increased the rate to 20%. 1 month later, he removed a statutory exemption for Chinese goods under $800. Less than a week after imposing the reciprocal tariffs, the president increased the rate of Chinese goods from 34% to 84%. The very next day, he increased the rate further still to 125%. This brought the total effective tariff rate on most Chinese goods to 145%. The president has also shifted sets of goods into and out of the reciprocal tariff framework, and he has issued a variety of other adjustments. For example, extending the suspension of heightened reciprocal tariffs on Chinese imports. Petitioners in Learning Resources and respondents in VOS Selections filed suit, alleging that that IEEPA does not authorize the reciprocal or drug trafficking tariffs. The Learning Resources plaintiffs, 2 small businesses, sued in the United States District Court for the District of Columbia. The VOS Selections plaintiffs, 5 small businesses and 12 states, sued in the United States Court of International Trade. The government moved to transfer the Learning Resources case to the CIT. It argued that the district court lacked jurisdiction under 28 U.S.C. subsection 1581 I-1, which gives the CIT exclusive jurisdiction of any civil action commenced against the government that arises out of any law of the United States providing for tariffs, or their administration and enforcement. The district court denied that motion and granted the plaintiff's motion for a preliminary injunction, concluding that IEEPA did not grant the president the power to impose tariffs. In the VOS Selections case, the CIT granted the plaintiff's motion for summary judgment. The Federal Circuit Court, sitting en banc, affirmed in relevant part. It first concluded that the CIT had exclusive jurisdiction because the plaintiff's claims arose out of modifications to the harmonized tariff schedule of the United States. On the merits, it agreed with the CIT that IEEPA's grant of authority to regulate importation did not authorize the challenged tariffs, which are unbounded in scope, amount, and duration. Judge Cunningham concurred for 4 judges, reasoning that IEEPA did not authorize the president to impose any tariffs. Judge Tartanto dissented for 4 judges, concluding that IEEPA authorized the challenged tariffs. The government filed a motion to expedite and a petition for certiorari in VOS Selections, and the Learning Resources plaintiffs filed a petition for certiorari before judgment. We granted the motion and petitions and consolidated the cases. Based on 2 words separated by 16 others in Section 1702A1B of IEEPA Regulate and Importation, the President asserts the independent power to impose tariffs on imports from any country of any product at any rate for any amount of time. Those words cannot bear such weight. Article 1, Section 8 of the Constitution sets forth the powers of the legislative branch. The first clause of that provision specifies that the Congress shall have the power to lay and collect taxes, duties, imposts, and excises. It is no accident that this power appears first. The power to tax was, Alexander Hamilton explained, the most important of the authorities proposed to be conferred upon the Union. It is both a power to destroy and a power necessary to the existence and prosperity of a nation, the one great power upon which the whole national fabric is based. The power to impose tariffs is very clearly a branch of the taxing power. A tariff, after all, is a tax levied on imported goods and services. And tariffs raise revenue, the defining feature of a tax. Indeed, the framers expected that the government would for a long time depend chiefly on tariffs for revenue. Little wonder then that the first Congress's first exercise of its taxing power and its second enacted law, right after the one providing for the new officials to take an oath, was a tariff law. Recognizing the taxing power's unique importance and having just fought a revolution motivated in large part by taxation without representation, the framers gave Congress alone access to the pockets of the people. They required all bills for raising revenue to originate in the House of Representatives, and in doing so, they ensured that only the House could propose the supplies requisite for the support of government, thereby reducing all the overgrown prerogatives of the other branches. They did not vest any part of the taxing power in the executive branch. The whole power of taxation rests with Congress. The government thus concedes, as it must, that the president enjoys no inherent authority to impose tariffs during peacetime, and it does not defend the challenged tariffs as an exercise of the president's war-making powers. The United States, after all, is not at war with every nation in the world. The government instead relies exclusively on IEPA. It reads the words regulate and importation to effect a sweeping delegation of Congress's power to set tariff policy, authorizing the president to impose tariffs of unlimited amount and duration on any product from any country. We have long expressed reluctance to read into ambiguous statutory text extraordinary delegations of Congress's powers. In Biden v. Nebraska, for example, we declined to read authorization to waive or modify statutory or regulatory provisions applicable to financial assistance programs as a delegation of power to cancel $430 billion in student loan debt. In West Virginia v. EPA, we declined to read authorization to determine whether the best system of emission reduction as a delegation of power to force a nationwide transition away from the use of coal. As in National Federation of Independent Businesses v. OSHA, we declined to read authorization to ensure safe and healthful working regulations as a delegation of power to impose a vaccine mandate on 84 million Americans. We have described several of these cases as major questions cases. In each, the government claimed broad, expansive power on an uncertain statutory basis, and in each, the statutory text might, as a matter of definitional possibilities, have been read to delegate the asserted power. But context counseled skepticism. That context included not just other language within the statute, but constitutional structure and common sense. Both separation of powers principles and a practical understanding of legislative intent suggested Congress would not have delegated highly consequential power through ambiguous language. These considerations apply with particular force where, as here, the purported delegation involves the core congressional power of the purse. Congress would likely intend for itself the basic and consequential trade-offs inherent in uses of this most complete and effectual weapon. And if Congress were to relinquish that power to another branch, a reasonable interpreter would expect it to do so clearly. What common sense suggests, congressional practice confirms, when Congress has delegated its tariff powers, it has done so in explicit terms and subject to strict limits. Congress has consistently used words like duty in statutes delegating authority to impose tariffs. It has capped the amount and duration of tariffs, and it has conditioned exercise of the tariff power on demanding procedural prerequisites. Against this backdrop, United States Trade Representative, consulting with relevant country interests. Against this backdrop of clear and limited delegations, the government reads IEPA to give the president power to unilaterally impose unbounded tariffs. On this reading, moreover, the president is unconstrained by the significant procedural limitations in other tariff statutes and free to issue a dizzying array of modifications as well. All it takes to unlock that extraordinary power is a presidential declaration of emergency, which the government asserts is unreviewable. And the only way of restraining the exercise of that power is a veto-proof majority in Congress. That view, if credited, would represent a transformative expansion of the president's authority over tariff policy. And indeed, as demonstrated by the exercise of that authority in this case, over the broader economy as well, it would replace the long-standing executive-legislative collaboration over trade policy with unchecked presidential policymaking. And the role of Congress in trade policy. Congress seldom effects such sea changes through vague language. It is also telling that in IEPA's half-century of existence, no president has invoked the statute to impose any tariffs, let alone tariffs of this magnitude and scope. Presidents have, by contrast, regularly invoked IEPA for other purposes. At the same time, they have invoked other statutes, but never IEPA, to impose tariffs on products ranging from car tires to washing machines. And those tariffs did not even begin to approach the size or scope of the IEPA tariffs at issue here. The lack of historical precedent for the IEPA's tariffs, coupled with the breadth of authority that the president now claims, is a telling indication that the tariffs extend beyond the president's legitimate reach. The economic and political significance of the authority the president has asserted likewise provides a reason to hesitate before concluding that Congress meant to confer such authority. The president's assertion here of broad statutory power over the national economy is extravagant by any measure. And as the government admits, indeed boasts, the economic and political consequences of the IEEPA tariffs are astonishing. The government points to projections that the tariffs will reduce the national deficit by $4 trillion and that international agreements reached in reliance on the tariffs would be worth $15 trillion. In the president's view, whether we are a rich nation or a poor one hangs in the balance. These stakes dwarf those on other major questions cases. As in those cases, a reasonable interpreter would not expect Congress to pawn such a big-time policy call off to another branch. The government and the principal dissent attempt to avoid application of the major questions doctrine on several grounds. None is convincing. The government argues first that the doctrine should not apply to emergency statutes, but this argument is nearly identical to the one it already advanced in Nebraska. There, the government contended that a different emergency statute should be interpreted broadly because its whole point was to provide substantial discretion to respond to unforeseen emergencies. We rejected that argument in Nebraska, and we reject it here as well. Emergency powers, after all, tend to kindle emergencies. Dozens of IEPA emergencies remain ongoing today, including the first declared over 4 decades ago in response to the Iranian hostage crisis. And as the framers understood, emergencies can't afford a ready pretext for usurpation of congressional power. Where Congress has reason to be worried about its powers slipping through its fingers, we in turn have every reason to expect Congress to use clear language to effectuate unbounded delegations, particularly of its one great power. The government's and the principal dissent's proposed foreign affairs exception fares no better. As a general matter, the president, of course, enjoys some independent constitutional powers over foreign affairs even without congressional authorization, and Congress certainly may intend to give the president substantial authority and flexibility in many foreign affairs or national security contexts. But flipping the presumption under the major questions doctrine makes little sense when it comes to tariffs. As the government admits, the president and Congress do not enjoy concurrent constitutional authority to impose tariffs during peacetime. The framers gave that power to Congress alone, notwithstanding the obvious foreign affairs implications of tariffs. And whatever may be said of other powers that implicate foreign affairs, we would not expect Congress to relinquish its tariff power through vague language or without careful limits. The central thrust of the government's and the principal dissent's proposed exceptions appear to be that ambiguous delegations in statutes addressing the most major of major questions should necessarily be construed broadly. But it simply does not follow from the fact that a statute deals with major problems that it should be read to delegate all major powers for which there may be a colorable textual basis. It is in precisely such cases that we should be alert to claims that sweeping delegations, particularly delegations of core congressional powers, lurk in ambiguous statutory text. There is no major questions exception to the major questions doctrine. Accordingly, the president must point to clear congressional authorization to justify his extraordinary assertion of the power to impose tariffs. He cannot. To begin, IEPA authorizes the president to investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent, or prohibit importation or exportation. Absent from this lengthy list of powers is any mention of tariffs or duties. That omission is notable in light of the significant but specific powers Congress did go to the trouble of naming. It stands to reason that had Congress intended to convey the distinct and extraordinary power to impose tariffs, it would have done so expressly, and it consistently has in other tariff statutes. The power to regulate importation does not fill that void. Regulate, as that term is ordinarily used, means to fix, establish, or control, to adjust by rule, method, or established mode, to direct by rule or restriction, to subject to governing principles or laws. This definition captures much of what a government does on a day-to-day basis. Indeed, if regulate is as broad as the principal dissent suggests, then the other 8 verbs in subsection 1702 A1b are simply wasted ink. But the facial breadth of regulate places in stark relief what the term is not usually thought to include: taxation. The U.S. Code is replete with statutes granting the executive the authority to regulate someone or something. Yet the government cannot identify any statute in which the power to regulate includes the power to tax. The government concedes, for example, that the Securities and Exchange Commission cannot tax the trading of securities, even though it is expressly authorized to regulate the trading of securities. We are therefore skeptical that in IEPA and IEPA alone, Congress hid a delegation of its birthright power to tax within the quotidian power to regulate. Taxes, to be sure, may accomplish regulatory ends, but it does not follow that the power to regulate something includes the power to tax it as a means of regulation. Congressional practice suggests as much. When Congress addresses both the power to regulate and the power to tax, it does so separately and expressly. See 16 U.S.C. subsection 460 BBB 9A, distinguishing between the power to tax persons, franchise, or private property on islands and the power to regulate the private islands. Subsection 622 8BI. Government-sponsored enterprises. The government-sponsored enterprise does not have the power to tax or to regulate interstate commerce. That is unsurprising, as the power to regulate commerce is entirely distinct from the right to levy taxes. That Congress did not grant those authorities separately here is strong evidence that regulate in IEPA does not include taxation. A contrary reading would render IEPA partly unconstitutional. IEPA authorizes the president to regulate importation or exportation. Taxing exports, however, is expressly forbidden by the Constitution. The neighboring words in which regulate is associated also suggest that Congress did not intend for regulate to include the revenue-raising power. Regulate is one of 9 verbs listed in subsection 1702A1B. Each authorizes a distinct action a president might take in sanctioning foreign actors or controlling domestic actors engaged in foreign commerce, blocking imports, for example, or prohibiting transactions. Presidential practice under IEPA demonstrates as much. None of the IEPA's authorities includes the distinct and extraordinary power to raise revenue, and the fact that no president has ever found such power in IEPA is strong evidence that it does not exist. We do not attempt to set forth the metes and bounds of the president's authority to regulate importation under IEPA. That interpretive question is not at issue in this case, and any answer would be plain dicta. Our task today is to decide only whether the power to regulate importation, as granted to the president in IEPA, embraces the power to impose tariffs. It does not. The government, echoed point for point by the principal dissent, marshals several arguments in response. First, it contends that IEPA confers the power to impose tariffs because early commentators and this court's cases discuss tariffs in the context of the Constitution's Commerce Clause. But that answers the wrong question. The question is not, as the government would have it, whether tariffs can ever be a means of regulating commerce. It is instead whether Congress, when conferring the power to regulate importation, gave the president the power to impose tariffs at his sole discretion. And Congress's pattern of usage is most relevant to answering that question. That pattern is plain. When Congress grants the power to impose tariffs, it does so clearly and with careful constraints. It did neither here. The government raises another contextual argument. Because regulate lies between two poles in IEPA, compel on the affirmative end and prohibit on the negative end, the term naturally includes the less extreme, more flexible tool of tariffs. But tariffs, as discussed above, are different in kind, not degree, from the other authorities in IEPA. Unlike those authorities, tariffs operate directly on domestic importers to raise revenue for the Treasury. Even though a tariff is, in some sense, less extreme than an outright compulsion or prohibition, it does not follow that tariffs lie on the spectrum between those poles. They are instead very clearly a branch of the taxing power, and fall outside the spectrum entirely. Finding no support in the statute the president invoked, the government turns to one he did not, IEPA's predecessor, TWEA, or TWE. In 1975, the Court of Customs and Patent Appeals held that the authority to regulate importation in TWE authorized President Nixon to impose limited tariffs. When Congress enacted IEPA 2 years later, the government contends it conveyed that same authority. This argument cannot bear the weight the government places on it. While this court sometimes assumes that Congress incorporates judicial definitions into legislation, we do so only when the term's meaning was well settled before the adoption. A single expressly limited opinion from a specialized intermediate appellate court does not clear that hurdle. The tariff authority asserted by President Nixon, moreover, was far removed from TWE's original purposes of sanctioning foreign belligerents. We are therefore skeptical that Congress enacted IEPA with an eye toward granting that novel power. The government has another historical argument based on this court's wartime precedents. According to the government, those precedents acknowledge an inherent presidential power to impose tariffs during armed conflict, and the argument goes, Congress in TWE and then in IEPA codified those precedents. But this argument fails at both steps. Insofar as the government relies on our wartime cases themselves, they are facially inopposite. Regardless of what they might mean for the president's inherent wartime authority, all agree that the president has no inherent peacetime authority to impose tariffs. Nor are we persuaded that the dots connect from our wartime precedents through multiple iterations of TWE to IEPA such that IEPA should be interpreted to grant the president an expansive peacetime tariff power. This argument relies extensively on a series of inferences drawn from scant legislative history. Such an attenuated claim cannot support, much less clearly support, a reading of IEPA that includes the distinct power to impose tariffs. Turning to this court's precedents, the government first relies on Federal Energy Administration v. Algonquin. There, we held that Section 232B of the Trade Expansion Act of 1962, which allows the president to adjust the imports of particular goods to protect national security, includes the power to impose license fees. But that holding bears little on the meaning of IEPA. As a textual matter, Section 232B authorizes the president not only to adjust imports, but, as the government emphasized in Algonquin, to take such action as he deems necessary to adjust the imports of a good. IEPA does not contain such sweeping discretion-conferring language as for context, Section 232A states that no action shall be taken to decrease or eliminate an existing duty or other import restriction, if doing so would threaten national security. This explicit reference to duties preceding Section 232B renders it natural for Section 232B itself to authorize duties. Thus, we decline to extend Algonquin's expressly limited holding any further. Finally, the government invokes Dames and Moore v. Reagan, but that case offers no support. Dames and Moore was exceedingly narrow, did not address the president's power to regulate, and did not involve tariffs at all. If anything, that case highlights the importance of close attention to IEPA's text. The terms of IEPA, we held, do not authorize the suspension of claims. So too here, the term of IEPA do not authorize tariffs. The president asserts the extraordinary power to unilaterally impose tariffs of unlimited amount, duration, and scope. In light of the breadth, history, and constitutional context of that asserted authority, he must identify clear congressional authorization to exercise it. IEPA's grant of authority to regulate importation falls short. IEPA contains no reference to tariffs or duties. The government points to no statute in which Congress used the word regulate to authorize taxation, and until now, no president has read IEPA to confer such power. We claim no special competence in matters of economics or foreign affairs. We claim only, as we must, the limited role assigned to us by Article 3 of the Constitution. Fulfilling that role, we hold that IEPA does not authorize the president to impose tariffs. The judgment of the United States Court of Appeals for the Federal Circuit in case number 25-250 is affirmed. The judgment of the United States District Court for the District of Columbia in case number 24-1287 is vacated, and the case is remanded with instructions to dismiss for lack of jurisdiction. It is so ordered. Justice Gorsuch concurring. The President claims that Congress delegated to him an extraordinary power in the International Emergency Economic Powers Act, IEPA, the power to impose tariffs on practically any products he wants, from any countries he chooses in any amounts he selects. Applying the major questions doctrine, the principal opinion rejects that argument. I join in full. The Constitution lodges the nation's lawmaking powers in Congress alone, and the major questions doctrine safeguards that assignment against executive encroachment. Under the doctrine's terms, the president must identify clear statutory authority for the extraordinary delegated power he claims, and as the principal opinion explains, that is a standard he cannot meet. Whatever else might be said about Congress's work in IEPA, it did not clearly surrender to the president the sweeping tariff power he seeks to wield. Not everyone sees it that way. Past critics of the major questions doctrine do not object to its application in this case, and they even join much of today's principal opinion. But they insist they can read the same result by employing only routine tools of statutory interpretation. Meanwhile, one colleague who joins the principal opinion in full suggests the major questions doctrine is nothing more than routine statutory interpretation. Still, others who have joined major questions decisions in the past dissent from today's applications of the doctrine. Finally, seeking to sidestep the major questions doctrine altogether, one colleague submits that Congress may hand over to the President most of its powers, including the tariff power, without limit. It is an interesting turn of events. Each camp warrants a visit. Start with the critics. In the past, they have criticized the major questions doctrine for two main reasons. The doctrine they have suggested is a novelty without basis in law, and they have argued the doctrine is rooted in an anti-administrative state stance that prevents Congress from employing executive agency officials to do important work. Today, the critics proceed differently. They join a section of the principal opinion that applies to the major questions doctrine. And rather than critique the doctrine, they say only that it is unnecessary in this case because ordinary principles of statutory interpretation lead to the same result. Unpack that last claim first. My concurring colleagues contend that as a matter of straight-up statutory construction, IEPA does not grant the President the power to impose tariffs. In doing so, they make thoughtful points about the statute's text and context. But their approach today is difficult to square with how they have interpreted other statutes. Dissenting in past major questions cases, they have argued that broad statutory language granting powers to executive officials should be read for all it is worth. Yet now, when it comes to IEPA's similarly broad language granting powers to the President, they take a more constrained approach. Consider some examples of how they have proceeded in the past. Dissenting in National Federation of Independent Businesses v. OSHA, two of my concurring colleagues confronted a statute charging the Occupational Safety and Health Administration with promoting safe and healthful working conditions. In support of their reading, my colleagues stressed the statute's expansive language, another provision authorizing the agency to issue temporary emergency standards, and the scope of the crisis the agency was trying to address. Dissenting in Alabama Association of Realtors v. Department of Health and Human Services, my colleagues addressed the statute permitting the Centers for Disease Control and Prevention to issue regulations necessary to prevent the transmission of communicable diseases. As they saw it, those terms granted the agency the power to regulate landlord-tenant relations nationwide during COVID-19. In reaching this conclusion, my colleagues again highlighted the statute's broad language and suggested that it permitted the agency to impose even greater restrictions than the ones at issue in the case. Dissenting in West Virginia, my colleagues faced a statute allowing the Environmental Protection Agency to ensure power plants employ the best system of emission reduction. They read that provision as authorizing the agency to effectively close many power plants and transform the electricity industry from coast to coast. In support, they once more argued that the statutory language was broad and expansive with no ifs, ands, or buts. They stressed, too, that the relevant statutory terms appeared in major legislation intended to address big problems, and that the statute authorized actions in the agency's traditional lane or wheelhouse. Finally, dissenting in Biden v. Nebraska, my colleagues took up a statute permitting the Secretary of Education to waive or modify any statutory or regulatory provision applying to a federal student loan program during a national emergency. They said that language allowed the Secretary to cancel $430 billion in federal student loan debt because of COVID-19. Once again, they argued that the statutory terms were broad, expansive, capacious, and designed to afford the Secretary a potent power to respond to national emergencies that were major in scope. Now compare all that to how my colleagues proceed here. This case, they say, is nearly the opposite. While straight-up statutory interpretation granted executive officials all the power they sought in all those other cases, my colleagues insist this one is different because IEPA simply does not give the President the power he wants. That's a striking turn given the statutory terms before us. When the President declares a national emergency to deal with any unusual, extraordinary threat to the national security, foreign policy, or economy of the United States, IEPA permits him to regulate importation of any property in which any foreign country or a national thereof has any interest. Surely the authority granted here is broad and expansive. It has no ifs, ands, or buts either. As a matter of ordinary meaning, the term regulate means to fix, establish, or control, adjust by rule, method, or established mode, direct by rule or restriction, or subject to governing principles or laws. And tariffs do just that. They fix rules that control, adjust, or govern imports of property in which any foreign country or national thereof has any interest. Without question, IEPA is also major legislation designed to address big problems and crises, along with emergencies that are major in scope. By its terms, the statute applies only during declared national emergencies involving threats to the national security, foreign policy, or economy of the United States. And it tasks the president personally with responding to those emergencies, a responsibility surely more in his lane or wheelhouse than that of any other executive official. Notably, too, IEPA grants the president the power to impose even greater restrictions than tariffs, because the statute also permits him to nullify, prevent, and void imports. Why do my concurring colleagues read IEPA so much more narrowly than they have other broad statutory terms found in other major legislation addressing other emergencies? They say contextual clues justify a narrowing construction here. But what the concurrence calls context looks remarkably like the major questions doctrine's rule that when executive branch officials claim Congress has granted them an extraordinary power, they must identify clear statutory authority for it. Take some examples. The concurrence points to the unparalleled authority the president asserts to impose a tariff of any amount for any time on only his own say-so. In other words, the president claims an extraordinary power. The concurrence observes that no president until now understood IEPA to authorize imposing tariffs. In other words, the power is an unheralded one. Along the way, the concurrence also adds a modicum of common sense about how Congress typically delegates, and consideration of whether Congress ever has before, or likely would, delegate the power to the and consideration of whether Congress ever has before, or likely would, delegate the power the executive asserts. In other words, the statutory text must be read in light of separation of powers principles. Having borrowed all the concepts from the major questions doctrine, the concurrence then turns to the key statutory terms before us, regulate importation, and observes that they say nothing, at least not expressly, about imposing tariffs. And why is that fatal to the president's case? Because the president is attempting to exercise the core congressional power over taxes and tariffs, a power Article 1 of the Constitution vests in Congress alone. If my colleagues all but apply the major questions doctrine today, maybe they are simply recognizing what they have in other separation of powers cases involving the delegation of legislative power, that the guidance needed is greater when the executive branch seeks to take actions that will affect the entire national economy. Or maybe my colleagues believe the power the president asserts here outstrips even those powers executive officials asserted in our past major questions cases. But whatever the case, my concurring colleagues' course today suggests that skeptics owe the major questions doctrine a second look, all of which leads me to take up the challenge they have posed to it in the past. Is the doctrine really some special canon that has only recently magically appeared? And is it really grounded in an anti-administrative state stance that prevents Congress from using executive branch officials to perform important work? The major questions doctrine teaches that to sustain a claim that Congress has granted them an extraordinary power, executive officials must identify clear authority for that power. Far from a novelty, much the same principle has long applied to those who claim extraordinary delegated authority, whether in private or public law. Examples stretch across many fields. Consider first the common law of corporations. In early modern England, corporations could be formed only with an explicit ex ante and direct authorization. That authorization could be given by the Crown, an act of Parliament, or a combination of the two. Some of these corporations exercised regulatory functions not unlike those performed by modern administrative agencies. Indeed, the initial settlements in Virginia and Massachusetts Bay, among others, were structured as corporations. English law treated these corporations as having authority to issue bylaws, but that authority was subject to restrictions, one of which was that corporations could not regulate on major subjects without express authorization. That case involved the Company of Cutlers, a corporation for makers of knives and other cutlery. An act of parliament gave the company broad authority to regulate its members. The company used that authority to adopt a bylaw allowing its officials to enter its members' workshops and warehouses and search for deceitful and unworkmanly cutlery. After the company seized supposedly unworkmanly forks, the aggrieved owner challenged the company's actions in court, arguing that the bylaw under which it acted was bad in point of law because the power to incur a forfeiture was not expressly given to the company by Act of Parliament. Applying a clear statement rule, the King's Bench declared the bylaw and therefore the seizure unlawful. Lord Mansfield explained that the power of making bylaws to incur a forfeiture was an extraordinary power over and above the default powers of corporations created by charter. For this reason, the power needed to be expressly given by the company's progenitor, Parliament. Since no such power has been clearly conferred, the seizure was unlawful. The same principle applies in American law. In re-election of directors of Long Island Company v. In re-election of directors of Long Island Company, a New York court addressed a case involving 2,700 shares of stock in the Long Island Railroad Company that the company had declared forfeited. All agreed that the company had broad power to regulate its shares. Still, the court called the forfeiture an extraordinary penalty and held that no such power had been expressly conferred on the corporation by its charter. In fact, the court borrowed the statement rule from Nowell. If extraordinary authority is intended to be given, it must be by express words to that effect. The court in Ex parte Burnett proceeded similarly. That case involved the incorporated town of Cahaba, Alabama. The town set the price of a liquor license at $1,000, fined James Burnett for failing to obtain one, and eventually imprisoned him for not paying the fine. Burnett sought a writ of habeas corpus and argued that Cahaba had acted beyond the scope of its corporate authority. Without a clear rule statement, Burnett's argument would have stood little chance. That's because the town's charter granted it the authority to make and establish all such rules, bylaws, and ordinances respecting the streets, markets, buildings, and police of said town, that shall appear to them requisite and necessary for the security, welfare, and convenience of said town, or for preserving health, peace, order, and good government within the same. The charter even specifically gave the town the privilege of granting licenses for retailing of spirituous and other liquors. Semantically, the town's power was broad indeed and encompassed liquor licensing, but the court sided with Burnett anyway. Reasoning that the town's exorbitant license fee effectively banned the sale of liquor, the court held that Cahaba did not enjoy such extraordinary prohibitory power because it was not authorized by any express grant of power in the town's charter. These cases are not outliers. Treaties confirm that the extraordinary power principle was fundamental to municipal corporations. A statute could not by implication invest a body with any extraordinary authority. Extraordinary powers required express words to that effect, and any fair, reasonable doubt concerning the existence of powers was resolved by the courts against the corporation, and the power was denied. The takeaway is simple enough. Early corporations often functioned much like today's executive branch, exercising delegated regulatory authority. And when interpreting the scope of that authority, the common law had a clear statement rule that looked strikingly like the major questions doctrine. Historically, a similar precept applied in an agency law. As the leading early American treaties put it, the instruments conferring powers of attorney were ordinarily subjected to a strict interpretation. A principal had delegated for example, in Atwood v. Munnings, a principal had delegated broad power to an agent to act generally for him and in his name, including in all things as should be requisite, expedient, and advisable to be done in his affairs and concerns, and as he might or could do if personally acting therein. The agent then accepted certain debts on behalf of the principal. The question for the court was whether this action was within the scope of the agent's authority. The court said no. Powers of attorney are instruments to be construed strictly, and the power of attorney contained no express power to accept debts, so no such power had been given. Other examples abound. A power to sell casks of whiskey did not include the unusual and extraordinary power to offer a warranty against future seizures of the casks, unless granted by express authority. Under a power of attorney, authority to enter contracts for a principal was subject to strict interpretation and generally did not authorize contracts of an extraordinary character, outside those connected with the principal's ordinary business. And a power to manage a mine did not authorize an agent to borrow money for the mine's operations on the principal's credit because there was no express authority for such a departure from the usual manner of running a mine. This was true even in cases of necessity where the manager borrowed funds to address an emergency suddenly arising. Much the same principle applied to executive officials. Often the legality of an executive action depended on the relationship between the size of the asserted power and the clarity of the underlying legal authority. Offers an illustration. There, as part of an investigation for seditious libel, the English Secretary of State claimed authority to issue a warrant. Much of the same principle applied to executive officials. Often the legality of an executive action depended on the relationship between the size of the asserted power and the clarity of the underlying legal authority. Oh, it is that way. All right. Partisan legal traditions in the age of Camden and Mansfield legal studies. Entick v. Carrington offers an illustration. There, as part of investigation for seditious libel, the English Secretary of State claimed authority to issue a warrant for the seizure of an author's papers. Lord Camden declared the seizure unlawful, reasoning that power asserted by the executive ought to be as clear as it is extensive. Or, as another reporter described Camden's decision, one should naturally expect that the law to warrant the exercise of power should be clear in proportion to as the power is exorbitant. The seizure represented an extraordinary exercise of power, Lord Camden found, and no legal authority clearly authorized it. Accordingly, the warrant was unlawful and the seizure could not stand. Perhaps unsurprisingly, given this history, American courts applied the extraordinary power principle when Congress and the states started delegating new regulatory powers to executive agencies in the late 19th century. Take railroad commissions. After the Civil War, governments worried about the increasing power of railroad companies responded by creating new agencies and imbued them with broad regulatory authority. These bodies were among the first modern administrative agencies, and when they claimed some extraordinary delegation of power, both state and federal courts enforced a clear statement rule. The railroad commissions may have been the first, but they were not the last. Whether executive officials claimed the power to criminally punish noncompliance with regulations, force employers to retain employees regardless of their unlawful conduct, or regulate intrastate candy sales, this court held them to much the same standard. Because their claimed powers were so substantial, executive officials had to identify a distinct authority for them. A clear legislative basis, a definite and unmistakable expression, or a clear mandate. It is no mystery why the court proceeded this way when interpreting legislative directions to the executive branch. Article 1 of the Constitution vests all federal legislative powers in Congress, and Article 2 charges the executive branch with seeing that Congress's laws are faithfully executed. In a very real sense, then, when it comes to legislative power, Congress is the principal and executive officials are the agents. So what is the basis for the charge that the major questions doctrine represents some magical innovation? Part of the answer may have to do with the fact that in the latter half of the 20th century, this court began experimenting with a very different approach. The court pushed aside its long-held skepticism of claims of extraordinary delegated powers and began affirmatively encouraging them. Chevron deference is just one example of this phenomenon, though a stark one. That case established a presumption that was nearly the opposite of the major questions doctrine. When Congress failed to speak clearly, courts put a thumb on the scale in favor of delegated power. Given that development, the long-standing principles animating animating the major questions doctrine may have receded from view for a time. After all, the two doctrines often applied in the same places and counseled opposite results. But with Chevron gone, so is the conflict. This court's application of the major questions doctrine is not invention so much as return to form. Now turn to my concurring colleague's other charge, that the major questions doctrine is premised on an anti-administrative state stance. It is important, they argue, to allow Congress to delegate expansive powers. Members of Congress, unfortunately, often don't know enough and know they don't know enough to regulate sensibly on an issue, nor can Congress easily anticipate changing circumstances. For these reasons, members of Congress must rely on more adept and less constrained people found in agencies. Indeed, my colleagues say administrative delegations have helped to build a modern nation, and the major questions doctrine, they worry, could jeopardize all that astonishing progress. This policy complaint, of course, is no reason to disregard our precedents or long-standing legal principles. But even taken on its own terms, it is a bit perplexing. The major questions doctrine is not anti-administrative state. It is pro-Congress. Common law courts understood that few written instruments can anticipate every eventuality, and that principles sometimes draft broad delegation language to account for this. At the same time, courts appreciated the corresponding risk that delegees could easily exploit loose language in their commissions for their own benefit and to the detriment of those they purported to serve. So common law courts often strictly construed delegated powers not because they were anti-delegee, but because they were pro-principle. The major questions doctrine performs a similar function. Article 1 vests all federal legislative powers in Congress, but like any written instrument, federal legislation cannot anticipate every eventuality, a point my concurring colleagues have observed in the past. And highly resourceful members of the executive branch have strong incentives to exploit any doubt in Congress's past work to assume new power for themselves. The major questions doctrine helps prevent that kind of exploitation. Our founders understood that men are not angels, and we disregard that insight at our peril when we allow the few or the one to aggrandize their power based on loose or uncertain authority. We delude ourselves too if we think that power will accumulate safely and only in the hands of dispassionate people found in agencies, even if unelected agency officials were uniquely immune to the desire for more power, an unserious assumption. They report to elected presidents who can claim no such modesty. Another feature of our separation of powers makes the major questions doctrine especially salient. When a private agent oversteps, a principal may fix that problem prospectively by withdrawing the agent's authority. Under our Constitution, the remedy is not so simple. Once this court reads a doubtful statute as granting the executive branch a given power, that power may prove almost impossible for Congress to retrieve. Any president keen on his own authority, and again, what president isn't, will have a strong incentive to veto legislation aimed at returning the power to Congress. Perhaps Congress can use other tools, including its appropriation authority, to influence how the president exercises his new power. Maybe Congress can sometimes even leverage those tools to induce the president to withhold a veto. But retrieving a lost power is no easy business in our constitutional order. And without doctrines like major questions, our system of separated powers and checks and balances threatens to give way to the continual and permanent accretion of power in the hands of one man. That is no recipe for a republic. This case offers an example of the problem. Article 1 grants Congress, not the president, the power to impose tariffs. Still, the president claims Congress passed that power on to him in IEEPA, permitting him to impose tariffs on nearly any goods he wishes, in any amount he wishes, based on emergencies he himself has declared. He insists as well that his emergency declarations are unreviewable. A ruling for him here, the president acknowledges, would afford future presidents the same latitude he asserts for himself. So another president might impose tariffs on gas-powered automobiles to respond to climate change, or really on virtually any imports for any emergency any president might perceive. And all of these emergency declarations would be unreviewable. Just ask yourself, what president would willingly give up that kind of power? I recognize the concerns about the major questions doctrine, but it is not so novel as some have supposed, and it serves Article 1 values we all share. My concurring colleagues all but endorse it today. I hope past skeptics will give it another look. Turn now to the second camp. If some have criticized the major questions doctrine, others have responded by seeking to soften its blow. Though joining today's principal opinion holding that clear statutory authority is required to sustain the exercise of an extraordinary power, Justice Barrett has suggested that the major questions doctrine might be reconceived. On her view, the doctrine need not be understood as a substantive canon designed to enforce Article 1's vesting clause. Instead, the doctrine might be thought of as a common sense principle of communication that counsels skepticism when executive officials claim extraordinary powers derived from Congress. It is a thoughtful effort, but I harbor doubts. For one thing, there is no need to reconceive our doctrine. Past critics all but apply the doctrine today, and their previous criticisms fall flat. For another, this gloss on our major questions doctrine presents problems. Common sense principles of communication do not explain many of our major questions cases, this one included. And if common sense really goes so far as to embrace a rule counseling skepticism of claims by executive officials that Congress has granted them extraordinary powers, that is common sense in name only. The reason for such skepticism must be Article 1, a substantive source external to any statute. Introducing her view that common sense principles of communication can sometimes help resolve disputes over the meaning of statutory terms, Justice Barrett points to an old chestnut. Suppose the legislature used the phrase, "Whoever drew blood in the streets" in a criminal statute imposing punishment. As a matter of common sense, Justice Barrett says, it would go without saying that the law doesn't apply to a surgeon accessing a patient's vein to save his life. That is because the phrase "drew blood" is susceptible to two conventional idiomatic meanings. One applicable to violent encounters with man or beast, and the other to medical procedures. And any ordinary person faced with that phrase in a penal law would find it obvious which meaning applies. The difficulty is our major questions cases are different. Often little about them goes without saying. Take FDA v. Brown and Williamson Tobacco Corporation. There, the question was whether the FDA could regulate tobacco products. Looking only to common sense, the answer would have been yes. Congress authorized the FDA to regulate drugs, which Congress defined expressly and broadly as articles other than food intended to affect the structure or any function of the body. As a matter of common sense, nicotine qualifies as a drug based on this statutory definition, as it might even as a matter of everyday speech. Still, we held the FDA could not regulate tobacco products. Other cases followed suit. We have ruled that the term air pollutant does not include greenhouse gases, even though greenhouse gases pollute the air. We have held that the phrase regulations necessary to prevent the spread of communicable diseases does not include eviction moratoriums, even without questioning that eviction moratoriums were necessary to prevent the spread of COVID-19, a communicable disease. And we have said that closing coal power plants is not the best system of emission reduction, even while acknowledging that closing them would reduce emissions. None of these cases can be readily explained by common sense principles of communication. None involved a phrase like "drew blood," susceptible to two conventional idiomatic meanings, one of which any English speaker faced with the law at issue might quickly rule out. Quite the opposite. In each case, the agency had a strong argument that the statutory language, commonsensically read, granted the power it claimed. Meanwhile, all our major questions cases can be easily explained by reference to a rule requiring the executive branch to identify clear statutory authority when it claims Congress has granted it an extraordinary power. And that is a dice-loading rule, plain and simple. One designed to protect Article 1, a substantive value external to the statutory terms at hand. Common sense not only fails to explain many of our major questions cases, it doesn't explain even some of the cases Justice Barrett has held up as examples of common sense cases. In Bond v. United States, for example, the court confronted a statute that defined chemical weapon to include any chemical which, through its chemical action on life processes, can cause death, temporarily incapacitation, or permanent harm to humans or animals. Despite that broad definition, the court held that arsenic-based compound didn't fit the bill. To reach that result, we did not use common sense alone. How could we have? It hardly goes without saying that arsenic doesn't qualify as a chemical which can cause permanent harm to humans or animals. Instead, we relied on clear statement rule grounded in the substance of the Constitution, namely the federalism canon. So bond weight may well be like our major questions cases, but that is only because it applied a clear statement rule grounded in another substantive feature of the Constitution. Consider as well the babysitter hypothetical Justice Barrett has posed. Imagine a parent of young children who hands a babysitter a credit card and says, make sure the kids have fun." Now suppose the babysitter takes the kids on a road trip to an amusement park where they spend 2 days on roller coasters and 1 night in a hotel. Was the babysitter trip consistent with the parent's instruction? Justice Barrett believes the answer is likely no, as a matter of common sense. Really, though, unless one is to believe children do not have fun on roller coasters and at hotels, the babysitter hypothetical can be explained only with reference to some external and substantive norm. And in fact, just such a norm is baked into the babysitter hypothetical, one we encountered in Part 1b. The babysitter is exercising authority the parents have delegated to her. She is acting as their agent. As a result, one might expect a clear statement from the parents before the babysitter may do something extraordinary, like take the kids on a road trip. This substantive norm about delegated powers not only lurks beneath the surface of the babysitter hypothetical, it loads the dice against her. Doubtless she would see it that way. The babysitter would argue that a trip to an amusement park is fun, and she would be right under a common sense understanding of the word. But because the babysitter is exercising delegated authority, she cannot exercise such an extraordinary power without clear authorization for it. Notice too, the same outcome is no longer guaranteed when we remove the delegated power feature. If one parent leaves the children with the other parent, the trip to the amusement park might well be fine. No other contextual clues are needed. So if the answer to the babysitter hypothetical seems a matter of common sense to many Americans, that is only because the substantive norms associated with parental delegations to babysitter agents are so deeply rooted in our society. Say the same instruction were given to a babysitter in a community where children are raised collectively, like a kibbutz. Same answer? Hardly obvious. To be sure, in places Justice Barrett concedes that her gloss on the major questions doctrine requires resort to something more than common sense instincts about what would go without saying to an ordinary English speaker. Sometimes she suggests common sense doesn't just help illuminate the most natural meaning of an idiomatic term like Drew blood, based on its presence in a penal law. Sometimes, she says, common sense principles of communication go much further, so much so that they wind up dictating a rule, counseling skepticism of executive claims to extraordinary delegated powers. Why? Because Justice Barrett says, a reasonable observer consults our constitutional structure, but if that's true, this version of common sense does require us to account for values entirely external to a statute, including specifically the substance of Article 1. And in doing so, this expanded version of common sense just becomes the substantive major questions doctrine by another name. Today's decision illustrates the point. The principal opinion gestures at common sense, but throughout this common sense is linked to constitutional structure and separation of powers principles. The principal opinion begins with the Constitution, observing that Article 1 vests the tariff power in Congress, not the executive branch. The principal opinion recounts the president's claim that Congress has delegated an extraordinary amount of its tariff power to him in IEEPA. And from there, the principal opinion proceeds to apply a clear statement rule. It acknowledges that the ordinary meaning of the key statutory term in IEPA, the word regulate, is capacious, so much so that it could be understood to capture much of what a government does. Still, the principal opinion reasons that is not enough to sustain the president's claim because the statute does not clearly grant him the extraordinary delegated power he seeks. When it comes down to it, common sense serves as little more than a segue to Article 1's vesting clause. That is as it must be. The statutory terms contain no ambiguity we could use or need. Common sense principles of communication common sense principles of communication to resolve. This case is nothing like the Drew Blood illustration, where it might go without saying that any ordinary person would immediately understand which of the two idiomatic meanings a penal statute employed. Indeed, today's principal opinion does not even attempt to set forth the metes and bounds of IEPA's key phrase, regulate importation, much less find the best or most natural meaning of those words. Instead, we need go no further than to recognize that IEPA fails to clearly authorize tariffs, and the only reason we can stop there is because Article 1, a substantive value external to a statute, imposed a clear statement rule when executive officials claim Congress has afforded them an extraordinary authority. There's another problem too. The equivocation on whether common sense principles of communication include only those things that might go without saying, or also include external and substantive Article 1 values, leads to a further equivocation on how much skepticism common sense might dictate when assessing an executive official's claim to an extraordinary delegated power. Common sense, we are told, does not impose a clarity tax, but it does add an expectation of clarity. Common sense does not load the dice, but it does counsel skepticism. Common sense means never foregoing the most natural reading of a statute, but it always means expecting that Congress will make the big-time policy calls. I am uncertain what to make of this, except that it seems to toggle between a clear statement rule and nothing at all. I am certain of one thing. Our cases hold a clear statement is required to support a claim to an extraordinary delegated power. We required Congress to speak clearly in utility error. We demanded clear congressional authorization in NFIB and in West Virginia. We did the same in Nebraska and in West Virginia, and we do so again today. Nor do I see cause for being quite so reluctant about acknowledging this. The common law recognizes many clear statement rules. Our own cases have applied a host of Constitution enforcing clear statement rules as well. We just encountered the federalism clear statement rule in Bond. As to the list clear statement rules against laws that might apply retroactively, waive or abrogate sovereign immunity, or create enforceable rights under the taxing clause, just to name a few. Maybe all these rules could be recast as common sense, at least if common sense means taking account of the external and substantive values found in our constitutional structure. But whatever the label, it hardly requires some judicial flex to recognize that the external constitutional values at stake in our major questions cases are no less weighty than those at play in other settings where we routinely apply a clear statement rule. That brings us to the third camp. My dissenting colleagues have defended the major questions doctrine in the past, and they do so again today. They agree that the doctrine is grounded in the Constitution. They agree that the doctrine requires us to deviate from routine statutory interpretation principles and instead place a thumb on the scale, one requiring executive officials to identify clear congressional authorization when they seek to exercise some major power. But my colleagues say IEPA provides the clear statement needed to sustain the president's tariffs. Alternatively, they submit we shouldn't apply the major questions doctrine to any statute like IEPA that implicate foreign affairs. And this exception, they add, is particularly warranted here because Congress has historically granted the president large discretion in setting tariffs. Once again, the points are thoughtful and merit careful consideration. My dissenting colleagues begin by taking the major questions doctrine as they find it. They accept that the president's challenged actions are of major economic and political significance. They accept as well that he must identify clear congressional authorization to sustain those actions. Still, the dissent maintains IEPA clearly grants the president the tariff power he asserts. To arrive at that conclusion, the dissent consults 4 clues we have sometimes employed in our major questions cases to help assess whether a statute clearly authorizes an asserted power. The dissent formulates these clues largely as I would, but to my eyes, the dissent engages in a little grade inflation when applying them. First, is the president seeking to exercise an unheralded or newfound power based on a long extant statute? The dissent insists that it is not the case here because President Nixon imposed a 10% tariff on most imports in 1971, and then defended that action in lower courts under a predecessor to the IPA, the Trading with the Enemies Act, or TWE. But the words regulate importation were added to TWE in 1941. Congress used the same language in IEPA in 1977, and in the 85 years of TWE's existence in that language and the 49 years of IEPA, 49 years of IEPAs, that is the only time either statute has been invoked to impose tariffs. A single time, and one never tested in this court, nor are these statutes seldom used. Each year since 1990, presidents have used roughly 4.5 executive orders and declared 1.5 new national emergencies citing IEPA. That is pretty strong evidence the president here seeks to deploy an old statute in a novel way. Second, how has the executive branch interpreted IEPA in the past? The dissent says presidents have long understood IEPA to permit them to impose tariffs. But for support, the dissent again relies on isolated evidence about other statutes. It points to the monetary exactions President Ford ordered under the Trade Expansion Act. And once more, it points to President Nixon's invocation of TWE to support his 1971 tariffs during lower court proceedings. Though the dissent brushes aside the fact that President Nixon initially rejected the idea of relying on TWE, whatever one makes of this history, it hardly reveals the kind of contemporaneous and consistent executive interpretation that might advance the dissent's case. To the contrary, the fact that no president until now has invoked IEPA to impose a duty, even 1% on one product from one country, is telling. Third, is there a mismatch between the action the executive official seeks to take and his expertise? On this one, I agree with the dissent. If tariffs fall in any executive official's wheelhouse and not Congress's, it's the president's. Fourth, is the president relying on oblique, elliptical, or cryptic language? The dissent says no, because this case does not involve elephants in mouse holes. Put another way, the dissent insists the provisions of IEPA before us are not ancillary ones, but are designed to convey significant powers. It's a fair enough point as far as it goes, but our cases ask not just whether a provision is a mouse hole or ancillary. They also caution against reading extraordinary powers into broad or general statutory language. Indeed, as we have seen, many of our major questions cases have found broad or general terms in significant statutes insufficient to support a claim to an extraordinary or unusual power. And here the word regulate is broad as it can be. So broad that it could be read to capture much of what a government does. As I see it, then, 3 of the 4 clues in the dissent relies on cut against it. It is important to add as well that as helpful as these clues can be in helping courts spot when a claimed power is not supported by clear statutory authority, they do not represent some exhaustive checklist, nor does satisfying one guarantee a claim will succeed. So, for example, even if an asserted power is in the agency's wheelhouse, we might rule, and have ruled, against the agency if the power is unheralded because the statute has stood for decades without being interpreted to convey the power claimed. Ultimately, the central question in any major questions case remains whether the executive branch's claim to an extraordinary power is supported by clear statutory authority, and as the principal opinion explains at length, many additional clues beyond those the dissent addresses confirm that the president cannot meet the standard in this case. These additional clues include the way the key statutory term regulate is used elsewhere in the U.S. Code, how Congress has delegated tariff authority in the past, and other neighboring language in the IEPA itself. Contrary to the dissent's charge to the principal opinion's application of the major questions doctrine today is in no way amount to a magic words test. Of course, if IEPA included terms like tariff or duty, that would have sufficed. But to borrow a phrase from the dissent, monetary exactions on foreign imports would have worked just as well. So, same goes for tax on imported goods, or any similarly clear term or phrase. But IEPA includes no such language, just a broad term that could cover almost anything a government does. And requiring specific rather than general language is just how Clear statement rules work. If the president's claim fails under our usual major questions test, the dissent says we should respond by carving out an exception to it for cases like this one touching on foreign affairs. On this score, I share a limited point of agreement with the dissent. Like the non-delegation doctrine, the major questions doctrine protects Article 1's vesting clause, and for that reason, the doctrine does not apply where the president is exercising only his own inherent Article 2 powers. Like the non-delegation doctrine, too, the major questions doctrine may speak with less force where the president and Congress enjoy overlapping authority. Doubtless, cases implicating overlapping powers can arise in the field of foreign affairs. The Constitution, for example, vests in Congress the power to raise and regulate armies, but it also vests in the president the commander-in-chief power. Similarly, Congress enjoys the power to regulate foreign commerce, but the president has power to negotiate treaties and nominate ambassadors. The president may even enjoy some residual powers pertaining to foreign affairs under Article 2's vesting clause, endowing him with the executive power. Given all this, it is easy enough to imagine statutes and disputes under them that implicate both congressional and presidential powers, where we might have reason to question whether the major questions doctrine applies with its usual force. The problem for the dissent is that none of this is relevant here. Before us, the president concedes that he does not enjoy independent Article 2 authority to impose tariffs in peacetime, nor does the president claim concurrent constitutional authority to issue his tariffs. Instead, and to his credit, the president admits the power to authorize tariffs in peacetime is constitutionally vested in Congress alone. Therefore, the president relies entirely on power derived from Congress, and that means the major questions doctrine applies in the normal way. Because of this problem, the dissent must argue for a much broader foreign affairs qualification to the major questions doctrine, rather than ask whether an independent, constitutionally vested presidential power is implicated. The dissent would have us ask instead whether the president seeks to use the statute in question for a foreign affairs purpose, for example, as a tool to incentivize a change in behavior by allies or enemies. When he does, the dissent submits the major questions doctrine should not apply. And that's true, the dissent continues, even if the power the president asserts has significant domestic ramifications. This new exception to the major questions doctrine would have enormous consequences hard to reconcile with the Constitution. Article 1, Section 8 vests in Congress many powers that touch on foreign affairs. Some of those powers were expected to be, and are, the principal objects of federal legislation. They include not only the power to impose tariffs, but also the power to establish uniform rules of naturalization, appropriate money for armies, and define and punish offenses against the law of nations. Under the dissent's view, all these legislative powers and more could be passed wholesale to the executive branch in a few loose statutory terms, no matter what domestic ramifications might follow. And as we have seen, Congress would often find these powers nearly impossible to retrieve. Consider an example. Imagine Congress adopted a law that arguably could be read to let the president borrow and spend money during peacetime as he sees fit. A law like that would represent an extraordinary delegation of Congress's power both to borrow on the credit of the United States and to spend money in support of the general welfare, and would carry with it significant domestic ramifications. But if an enterprising executive could also use the law as a tool for affecting the behavior of allies or enemies, the dissent seemingly would have us exempt it from scrutiny under the major questions doctrine. The dissent's exception is so broad, it's hard not to wonder how it fits with some of our existing major questions precedents. In West Virginia, the court applied the major questions doctrine over a dissent, expressing concern that doing so would deny the EPA, and therefore the president, the power to respond to the most pressing environmental challenge of our time: climate change. A challenge, the dissent continued, that threatened consequences global in scope, including mass migration events, political crises, civil unrest, and even state failure. Was West Virginia a foreign affairs case? How about our major questions cases addressing efforts to combat the global pandemic that was COVID-19? Seeking support for its sweeping new exception, the dissent points to three main precedents. I do not see how any of them might sustain its view. The first, Hamdi v. Rumsfeld, concerned the 2001 Authorization for Use of Military Force, the AUMF legislation, which authorized the president to use all necessary and appropriate force against those nations, organizations, and or persons responsible for the September 11th, 2001 attacks. The dissent highlights the principal opinion's conclusion that the AUMF allowed the president to detain enemy combatants even though the law did not mention that power expressly. And from this, the dissent draws the inference that any statute addressing foreign affairs should be exempt from scrutiny under the major questions doctrine. But the dissent overlooks the fact that the principal opinion reached the conclusion it did not only because it found detention of enemy combatants to be a traditional incident of war, and once Congress declares war, or likewise authorizes the use of military force abroad, that implicates the president's commander-in-chief powers. Put simply, Hamdi was a case of overlapping powers. Ours is not. Second, the dissent invokes Dames and Moore v. Reagan. At its heart, that case involved an executive order by President Reagan suspending certain claims by U.S. citizens against Iran as part of a settlement involving the release of American hostages held there. Just as we do today, Dames and Moore held that the terms of the IEEPA did not authorize the president's actions. Even so, the court proceeded to uphold those actions anyway, and did so based in part on its view, right or wrong, that the president enjoyed some independent power to enter into executive agreements suspending certain claims. So unlike our case, Dames and Moore again involved overlapping powers. Along the way, the court emphasized repeatedly the narrowness of its decision and that it should not be taken to lay down any general guidelines covering other situations not involved here. To derive from Dames and Moore a new general guideline exempting foreign affairs cases from the major questions doctrine's reach would thus require us to disregard its own cautionary direction. Third, the dissent cites United States v. Curtiss-Wright Export Corporation. There, the court did suggest that non-delegation rules in the field of domestic or internal affairs should differ from those in the realm of foreign or external affairs. But what should we make of that language? If it means that the non-delegation doctrine, and perhaps by extension the major questions doctrine, must account for the president's independent Article II powers. I agree. But I would hesitate to read more into the decision than that. Consider what was really at issue here: a statute permitting the president to ban the transfer of one class of goods, armaments. It did so with respect to two countries that engaged in a war, Bolivia and Paraguay. The president's authority was conditioned on finding that a ban may contribute to the reestablishment of peace between those countries. Before making that finding too, Congress directed him to consult with the governments of other republics. All told, then, the statute set forth the policy for the president to pursue. It bounded its authority by limiting his options with respect to a limited class of goods and countries. The statute further conditioned his exercise of those options on a factual finding reached after consultation with other nations. So whatever else might be said about Curtiss-Wright, one thing is apparent. In upholding the president's actions under the law in question, the court hardly allowed Congress to hand off all of its enumerated powers touching on foreign affairs to the president, the tariff power included. If its efforts to secure a broad foreign affairs exception to the major questions doctrine won't work, the dissent hints at a more limited one specific to tariffs. Such an exception makes sense, the dissent says, because presidents have long been granted substantial discretion over tariffs. Indeed, the dissent contends this tradition traces back to near the founding. If the dissent were right about that, one might hesitate before accepting the president's concession that this case does not implicate any inherent Article II authority. But at least as I read it, history offers the dissent little to work with. Americans fought the Revolution in no part because they believed that only their elected representatives, not the king, not even Parliament, possessed authority to tax them. And they believed that held true not just for direct taxes like those in the Stamp Act, but also for many duties on imports like those found in the Sugar Act. Citing the Stamp Act crisis. Americans later codified these beliefs in the Constitution. Under the Articles of Confederation, the national government was laden with debt and enjoyed few ways to repay it. To address that problem, the framers afforded the federal government new taxing powers in the Constitution. Article 1, subsection 8, clause 1. Many thought these powers among the most important features of the new federal charter. But, consistent with their view that only the people's elected representatives could constitutionally tax them, the framers gave Congress alone access to the pockets of the people. And to cement that rule, the Constitution required that all bills for raising revenue shall originate in the House of Representatives, the body most responsive to the people. For much of the nation's history, this taxing power was essentially a tariff power. The framers even considered, and eventually rejected, the possibility of giving the federal government the power to tax only through tariffs. No surprise, then, that Congress's first exercise of its taxing power was a tariff law. But under the 20th century, tariffs accounted for between 50 and 90% of the federal government's revenue. How did Congress exercise its all-important tariff power? It debated every detail of the first Tariff Act. Ultimately, Congress said imported malt would incur a charge of 10 cents a bushel, brown sugar 1 cent, loaf sugar 3 cents, and so on. The first Tariff Act was set to last for 7 years. It lasted barely one. Soon Congress was at it again, laying out another exacting schedule of duties. Throughout much of the 19th century, Congress proceeded similarly, enacting highly detailed tariff schedules one after another. An early debate over executive involvement in setting tariffs demonstrates just how strongly Congress felt that tariffs were a legislative business. In December 1791, President Washington told Congress that General St. Clair had been defeated in the Northwest Indian War, and the country would have to increase the size of the army. That meant the government needed more money. In response, a resolution was offered in the House of Representatives to solicit advice from the Secretary of the Treasury, Alexander Hamilton, on the best way to raise the additional revenue, including through new tariffs. Ultimately, Hamilton's advice was sought, but only after a debate over the constitutionality of even asking a member of the executive branch for advice on raising revenue. To be sure, on later occasions, Congress turned to the executive branch for more help still, but it usually did so to address changing trade practices in foreign countries. And in doing so, Congress set the important policies with the executive branch responsible for finding facts, like what other countries' trade policies were at any given moment, or filling in the details. So, for example, Congress passed a statute in 1815 to repeal any discriminating duty of tonnage whenever the president was satisfied that other countries' discriminating or countervailing duties had been abolished. Given this history, it's no surprise that the dissent relies mostly on statutes and cases after 1890. The statute the court faced in Marshall Field and Company v. Clark spoke similarly. Even when Federal Emergency Administration v. Algonquin came along in 1976, the court upheld. Given its history, it's no surprise that the dissent relies mostly on statutes and cases after 1890. But even they do little to support its claim. For example, J.W. Hampton Jr. and Company v. United States, for example, involved a law instructing the president to investigate the costs of production for American firms and their foreign counterparts and issue tariffs to equalize those costs. The statute the court faced in Marshall Field and Company v. Clark spoke similarly. Even when Federal Energy Administration v. Algonquin came along in 1976, the court upheld President Ford's imposition of monetary exactions on a single class of products under a statute that provided at least some guidance about how he should implement the law. And whether correctly decided or not, that case lies a far step from this one. Before us, the president insists he may use IEEPA to equalize foreign and domestic duties, or not. He may use it to negotiate with foreign countries, or not. He may set tariffs at 1% or 1,000,000%. He may target one nation and one product, or every nation and nearly every product. And he may change his mind at any time for nearly any reason. At least as I see it, history dating back to near the founding does not support the notion that presidents have traditionally enjoyed so much power. More nearly, history refutes it. That leaves one final camp to consider. Justice Thomas suggests that Congress may hand over most of its constitutionally vested powers to the president completely and forever. On his view, the only powers Congress may not delegate are those that involve rules setting the conditions for deprivations of life, liberty, or property. From this rule, it follows that Congress may give all its tariff powers to the president because importing is a matter of privilege. And as a result, this case does not implicate any separation of powers concerns at all. It's a sweeping theory, one that would require us to reimagine much of our case law addressing Article 1's vesting clause, and one that presents difficulties of its own. First, I do not see how Justice Thomas's theory resolves all separations of power concerns. Suppose, for argument's sake, that Congress can delegate its tariff powers to the president as completely as Justice Thomas suggests. Even then, the question remains whether Congress has given the president the tariff authority he claims in this case, or whether the president is seeking to exploit questionable statutory language to aggrandize his power. Put another way, Justice Thomas's non-delegation solution does not automatically solve the major questions problem. As we have seen, when an executive official claims Congress has delegated to him some extraordinary power, the major questions doctrine requires him to identify clear statutory authority for its exercise, a standard he must satisfy even if Congress is free to pass to him the powers he seeks. In fact, this court has previously applied, with our colleague's assent, the major questions doctrine in a case that appears, under his present view, to involve a power that Congress could delegate wholesale to the president. And just as the major questions doctrine precluded the executive branch's assertion of power in that case, it does so here. Quoting Nebraska, or referencing Nebraska. Second, even when it comes to the non-delegation doctrine, Justice Thomas's theory raises many concerns. I appreciate that the doctrine may apply with less force in certain areas, such as when Congress legislates in a way that implicates one of the president's inherent powers. But Justice Thomas would go much further. On his telling, the doctrine applies only to Congress's true legislative powers, which he says include only those powers addressing the deprivation of life, liberty, or property. As it turns out, only a small subset of Congress's enumerated powers in Article 1, subsection 8 fit that bill. Only those few powers are exclusively vested in Congress and subject to review of any kind under the non-delegation doctrine. All other kinds of powers enumerated in Article 1, subsection 8, including the powers to borrow and spend money, declare war, and regulate foreign trade, are not truly legislative and may be delegated at will. So Congress may hand them off to the president completely, and he has no need to worry about legal challenges under even this court's relatively lax delegation doctrine. No matter, too, that Congress might find itself permanently unable to retrieve these powers. But if all that's true, what do we make of the Constitution's text? Section 1 of Article 1 vests all legislative power herein granted in Congress and no one else. Section 8 proceeds to list those powers in detail and without differentiation. Neither provision speaks of some divide between true legislative powers touching on life, liberty, or property that are permanently vested in Congress alone and other kinds of powers that may be given away and possibly lost forever to the president. What do we make, too, of what the founders have said about Article 1 both before and after the Constitution's ratification? They regularly referred to powers in Article 1, subsection 8, even those that do not touch on life, liberty, or property as legislative in nature. At the Constitutional Convention, early drafts described the powers to regulate foreign commerce, raise armies, equip fleets, coin money, and establish post offices as legislative powers. James Madison wrote to Congress in 1817 that the legislative powers vested in Congress are specified and enumerated in the eighth section of the first article of the Constitution. Alexander Hamilton spoke similarly. Senate's powers as legislative powers, with the exception of the powers to try impeachments, concur in treaties, and consent to the appointment of officers, matters addressed, articles outside Section 1.8. Oh, this whole paragraph's just referencing it. Alexander Hamilton spoke similarly, discussing the legislative power to borrow money, describing the legislative power to regulating trade with foreign nations, calling of legislative kind and of a legislative nature the powers to raise money and troops, establish rules in all cases of capture by sea or land, regulate the alloy and value of coin, and make all laws for the government of the Army and Navy. So did James Wilson, describing all the Senate's Senate's powers as legislative powers, with the exception of the powers to try impeachments, concur in treaties, and consent to the appointment of officers, matters addressed outside of Article 1, subsection 8. What do we make as well of early congressional debates? In the Second Congress, for example, the House of Representatives rejected on non-delegation grounds a proposal to give the president a largely unfettered power to establish postal routes, even though doing so hardly would have touched on life, liberty, or property. In the Fifth Congress, 4 representatives likewise objected on non-delegation grounds to a bill that authorized the president to raise an army of up to 10,000 men. Though the bill ultimately passed, it did so apparently because it was deemed not to violate Article 1's non-delegation principle. No member of Congress responded that the principle was wholly inapplicable because the delegated power was not one that involved setting conditions for deprivation of life, liberty, or property. What are we to do with this court's non-delegation precedents, which have never turned on Justice Thomas's view of life, liberty, or property? Third, even if a distinction between true legislative powers and other kinds of powers were proper, I do not see why the tariff power would fall in the latter category and thus be something Congress could delegate away wholesale without scrutiny and forever. Justice Thomas suggests all that is possible because at the founding, the tariff power was considered a prerogative right of the British king. That seems doubtful. Tariffs may have been among the king's prerogative powers during the reign of Edward I, but even before the year 1400, Parliament had achieved some victory over the king in the matter of imposing import duties. And after the Glorious Revolution of 1688, as this court has put it, Parliament secured supremacy in fiscal matters. More importantly still, whatever the views in Britain may have been, American revolutionaries hardly shared some universal conviction that all manners of tariffs were a matter of the king's prerogative, or even something Parliament, lacking colonial representatives, could freely impose on them. Though in the mid-1760s, some colonists distinguished between internal and external taxation and conceded Parliament's right to raise revenue through duties on trade, the inadequacy of that much overstrained distinction soon became obvious. Illustrative of the point, John Dickinson came to repudiate the distinction flatly and formally in his Letters from a Framer in Pennsylvania, contending instead that laws aimed at raising revenue but enacted without representation were objectionable without distinction between internal and external taxes. And of course, it was duties on foreign tea that triggered the Boston Tea Party. Are we really to believe that the patriots that night in Boston Harbor considered the whole of the tariff power some kingly prerogative? As we have already seen too, the growing American conviction that the peacetime tariff power is legislative and belongs only to the people's elected representatives was later reflected in both the Constitution and early congressional practice. To that discussion, I would add just this. The Articles of Confederation granted the Confederation Congress authority to make commercial treaties, but no authority to restrain the legislative power of the respective states to impose import duties on foreigners. At the Constitutional Convention that followed, where the tariff power was transferred to the federal government, delegates likewise referred to it as a legislative power. And during debates over the Jay Treaty, Hamilton explained that he held no doubt that regulating foreign trade and raising money from it was a legislative power, if one that could be constrained by treaty. Reflecting the same sentiment that helped fuel the revolution, he asked, what legislative power can be more sacred? For those who think it important for the nation to impose more tariffs, I understand that today's decision will be disappointing. All I can offer them is that most major decisions affecting the rights and responsibilities of the American people, including the duty to pay taxes and tariffs, are funneling through the legislative process for a reason. Yes, legislating can be hard and take time, and yes, it can be tempting to bypass Congress when some pressing problems arise. But the deliberative nature of the legislative process was the whole point of its design. Through that process, the nation can tap the combined wisdom of the people's elected representatives, not just that one faction or man. Their deliberations Deliberation tempers impulse, and compromise hammers disagreements into workable solutions. And because laws must earn such broad support to survive the legislative process, they tend to endure, allowing ordinary people to plan their lives in ways they cannot when the rules shift from day to day. In all, the legislative process helps ensure each of us has a stake in the laws that govern us and in the nation's future. For some today, the weight of those virtues is apparent. For others, it may not seem so obvious. But if history is any guide, the tables will turn and the day will come when those disappointed by today's decision will appreciate the legislative process for the bulwark of liberty it is. All right, so we'll stop at part 1 there, and then we'll continue with part 2 tomorrow.